Good afternoon, everyone, and thank you for joining today's webinar, which will focus on the key aspects of the Central Bank's consultation paper, CP153, and the likely implications for regulated firms. My name is Rachel Turner, and I'm a partner in the Litigation and Dispute Resolution Department in Dillon Eustace. I'm also a member of the Dillon Eustace Cross-Departmental IAF team, and I'm joined today by my colleagues Colman O'Loughlin and Keith Waine. So Colman and Keith, if you could just briefly introduce yourself and your area of expertise for our listeners today.
Sure, thanks Rachel. So my name is Colman O'Loughlin. I'm a partner in the Asset Management and Funds team at Dillon Eustace. I sit on the internal working group with two other colleagues from the Asset Management team, and we focus our review of the framework on its applicability to the asset management industry in Ireland. So looking at the various aspects of the framework as they will apply to UCITS management companies, AIFMs, Supermancos and MiFID firms.
Thanks.
And my focus is a bit wider. Keith Waine, I head the financial regulation team in Dillon Eustace. We advise regulated firms from across the financial services industry on a range of regulatory issues, including governance requirements and fitness and probity requirements, which has naturally led us to considering the individual accountability framework.
Thanks both. So as outlined, our discussion today will focus on the key aspects of the Central Bank's consultation paper, which sets out how the Central Bank proposes to implement the new IAF. By way of background, the consultation paper was published on the 13th of March, following the signing into law on the 9th of March of the Central Bank Individual Accountability Framework Act 2023. So in short, the Act provides for the introduction of the IAF, which is intended to improve governance, performance and accountability in firms. And just by way of reminder, the IAF consists of 4 pillars: a senior executive accountability regime, otherwise known as SEER, conduct standards for both individuals and firms, enhancements to the current fitness and probity regime, and amendments to the Central Bank's administrative sanctions procedure. So it's clear from the consultation paper that the legislative framework constituting the IAF will consist of the Act, the implementing regulations and guidelines issued by the Central Bank. The consultation paper issued by the Central Bank contains draft regulations and guidance on certain aspects of the framework, such as SEER, the standards of conduct, and certain aspects of the fitness and probity regime. So Colman, if we could just move to you first to discuss the conduct standards and the time frame.
Sure, thanks Rachel. So today I'm going to look in detail at the conduct standards as they apply to regulated firms. And before I lose everyone's attention, I'm going to give my 3 key takeaways for the conduct standards. So firstly, the conduct standards, unlike SEER, apply to all regulated firms. There's no carve out. Number 2, unlike SEER, the applicable date or the proposed date for implementation of the conduct rules is the 31st of December of this year. And then finally, number 3, similar to SEER, a breach or a prescribed contravention of the conduct rules is directly enforceable against an individual by the Central Bank under the administrative sanctions procedure. And today for me is really emphasising how the conduct rules kind of apply in their own right. I think a lot of people, when they talk about the framework, automatically look to SEER. And we now know that obviously conduct rules will apply across the board from the get-go to all firms. That would include the kind of firms I mentioned at the outset, so UCITS, Mancos, AIFMs, those type of organisations. The conduct rules will apply to those firms. And then one other point to mention is on regulated investment funds. So we get questions a lot on whether the conduct rules and the framework in general will actually apply to funds. So that's unknown at the moment. We are clarifying that with industry, with the Central Bank, to see the applicability of the framework in general and then certain aspects of it to investment funds. But again, key takeaways on the conduct rules is applying to all firms with that implementation date later this year.
Great, thank you. And could you just provide an overview of the conduct rules then as set out in the 2023 Act?
Sure, and a lot of people might be familiar with the kind of standards as they're set out in the legislation, as the legislation obviously was going through draft form and was finalised recently, but it's worthwhile just setting the scene in terms of the various standards. So within the legislation, the standards are divided into three different areas. We have business standards, common standards and additional standards. Business standards, as the name suggests, apply at the entity or the firm level. What the central bank has said in relation to business standards is they are rules or standards that most firms will already hold themselves to. So for example, it's acting in the best interests of your customers and the integrity of the market, acting honestly, fairly, professionally, and acting with due skill, care and diligence. We then have the two other sets of standards which apply at the individual level, so persons working within firms that are in scope of the conduct rules. So firstly, we have the common conduct standards, they will apply to all persons who are control functions or CFs. Now that would also include PCFs or pre-approval control functions. Again, the central bank has said these are standard behaviours or standards that most individuals will be holding themselves to already. So that includes acting with honesty and integrity, acting with due skill, care and diligence, cooperating in good faith and without delay with the central bank, acting in the best interests of your customers and treating them fairly and professionally, and then operating in compliance with standard of market conduct and trading venue rules where that's applicable under relevant financial services legislation. We then have the additional conduct standards, again applying at the individual level. So the additional conduct standards will apply to all PCFs and CF1s. So PCFs we know, pre-approval control functions, and CF1s are persons that will have a significant impact on the conduct of the firm. So this is that additional layer for more senior individuals within a firm. So those types of standards include ensuring that the business of the firm is controlled effectively, that the business of the firm is operated in accordance with financial services legislation, that delegated tasks are assigned to appropriate persons with effective oversight, and then that any information that the central bank would reasonably expect it to be notified of is done so promptly and appropriately. So we can see there very kind of high level, broad, but there's also a huge amount in it. For a lot of the firms that we advise on a day-to-day basis, a UCITS management company, for example, a lot of the employees within that organisation are going to be at minimum CFs. A lot of them will be PCFs. So you can see the impact that these conduct rules in terms of the common and the additional will have on those organisations.
Mm-hmm. And in terms of any guidance that is issued, can you talk to us about the guidance that is issued by the central bank on the various conduct rules then?
Yeah, so the legislation itself prescribes that the central bank would be able to issue guidance on the individual conduct rules, and that's what it's done. And the idea behind that is, I suppose, to give a bit more colour around the standards. So giving context of what exactly the regulatory expectations are in terms of those standards. Business standards, what the guidance paper has said, will be developed in conjunction with the review and consultation of the Consumer Protection Code. So that's expected to happen later this year. So we're not going to dwell on that for the purpose of today's discussion, and we'll move on to the individual standards. So the guidance for the individual standards says that they're a single set of applicable standards of behaviour that apply to relevant persons in all firms. And the guidance goes on to state and make clear that the applicability of the conduct standards applies to a wider population than SEER. So again, this comes back to one of my key takeaways. The conduct standards apply across the board to all regulated firms, no carve out, and then obviously it's broken down within CFs, PCFs, etc. Within the common conduct standards, the guidance again confirms they apply to CFs, that they're basic standards that individuals will already hold themselves to. But what's helpful from the guidance is they actually build on the standards and, as I said, provide that little bit of context. So for example, when acting with due skill, care and diligence, an individual must have the appropriate knowledge of the legal and regulatory framework, whereby the person must keep themselves proactively up to date of developments as they relate to their role or their function. When we look at the additional conduct standards, we again, guidance confirms all PCFs, CF1s, And then again, it builds on the standards that's set out in the legislation. So again, to take some examples, to ensure that the business is controlled effectively, the individual must fully understand the business or the area of business for which they are responsible for, and keep themselves up to date with developments in that area. To ensure that the firm is conducted in accordance with financial services legislation, appropriate and up-to-date policies need to be put in place by the firm, notified to individuals, and then obviously individuals need to abide by those policies. In addition to that, individuals should seek to ensure that appropriate training is provided to them at an appropriate frequency. So for example, that could be updates to legal and regulatory matters, that they would need training on those specific areas, again, as they relate to their specific role or function. And then requests for ad hoc or additional training that they are met by the firm, and obviously individuals then will carry out that training as well. So really helpful, I suppose, to see it with a bit more colour and a bit more context around the standards themselves. Quite a bit in it, and certainly kind of helpful, I think, for individuals to know maybe how they can go about complying with those set standards.
Thanks. And I suppose, what about the independent non-executive directors? Do the conduct rules apply to those as well? Yes,
we get that question quite a bit from directors, and especially from the independent non-executive directors. So through various speeches over the last number of months by Jerry Cross and Gerbil Rowland from the Central Bank, it was made clear that the framework would apply to non-executive directors and INEDs as well. That was always framed maybe in the context of SEER. What we know now from the guidance is that both the common conduct standards and the additional conduct standards will apply to NEDs and INEDs. What they say, though, in respect of the common conduct standards, for example, when acting with due skill, care and diligence, many directors will obviously be doing that already in terms of the role that they have as the non-executive director. So the examples that the central bank provide are preparing for board meetings, actively participating in board meetings, etc. So again, it won't be too much of an additional ask for those types of directors. In terms of the additional conduct rules, they also confirm that they would apply to that type of director. But what they say is that that should be looked at in the context of their role. Those directors are not working day to day in the business of the firm, and therefore it should be looked at in that light in terms of the kind of expectation around such directors.
Okay, thank you, Colman. And Keith, if we could just move to you, and if you could outline the content and the scope of the new SEER rules and the time frame for application.
Sure. Well, I suppose the first thing to say is we know a lot more now about the SEER regime than we did last week. There was very scant detail in the original bill and act as it is now regarding the SEER regime. We now have the draft regulations and extensive guidance. So I suppose the first thing we're able to say is who it applies to. We suspected it would apply to banks, insurers and investment firms, and that is the case. In respect of insurers, it won't apply to reinsurers, it won't apply to captive insurers. In respect of investment firms, it will apply only to those investment firms who put their own balance sheet at risk, or who are authorised to hold client assets. So those firms that are trade on own account or that place financial instruments on a firm commitment basis will be in scope. Others, your typical broker advisory type MiFID firms will be out of scope for now. I say for now because the central bank has been very clear that they intend to roll out the SEER to other regulated firms in due course. We also know when it will apply, 1st of July 2024, and we know a little bit more about the content. So the obligations in the draft regulations, and they're not particularly lengthy, but it starts with an obligation on the firm to identify the areas of responsibility within the firm themselves, the areas of management responsibility, business activities, governance, structures, etc., and then to document that in what's referred to as a management responsibility map. In parallel with that process, there's an expectation that firms prepare what's referred to in the regulations as responsibility statements for each PSF or PCF rather within the regulated firm. These maps and responsibility statements are intended to be live documents. They can be made available to the central bank upon request, and there is an obligation to keep them for a period of 10 years.
Okay, thank you. And in terms of inherent and prescribed responsibilities, can you explain to us what they are and give us some examples?
Sure. Well, we now know what they are because they're listed in schedules to the draft regulations. So the inherent responsibilities are responsibilities which are assigned to particular PCFs. So each PCF will have an inherent responsibility. Thankfully, they're short and sweet. Give the example of the PCF 12, the head of compliance. Their inherent responsibility is to be responsible for the management of the compliance function and reporting to the board on compliance matters. So nothing that any compliance head of compliance in the country is going to be particularly concerned about in terms of the scope. And similar inherent responsibilities apply for the other PCF functions. The prescribed responsibilities then aren't assigned to any particular PCF. There is a list of them. I think there's 29 general prescribed responsibilities, and then there are some sector-specific responsibilities and some circumstance-specific responsibilities. The obligation in respect of those is to assign them to a PCF. In some cases, for some of those responsibilities, in particular, ensuring the independence of the control functions within the firm, there's an expectation that those, or a requirement rather, that those responsibilities will be assigned to a non-executive or independent non-executive director. For the rest of the prescribed responsibilities, things like responsibility for environmental risk, responsibility for diversity and inclusion, it's up to the firm to decide who those responsibilities should be assigned to. So I think there's likely to be a bit of horse trading around executive committees as to who should actually take on these responsibilities, particularly as responsibilities cannot be shared. So that the central bank have been very clear that the responsibilities have to be assigned to one individual and cannot be shared, except in the case of a job sharing arrangement where you've got two individuals carrying out the same job. Yeah, that's probably the extent of what we know on the responsibilities. And sorry, there is one other element is the other responsibilities, and they are referred to as other responsibilities within the regulations. And they're responsibilities which are identified by the firm itself as part of the mapping exercise which they carry out. So the idea being that there are no gaps in responsibilities of a particular firm. So there is a positive obligation on the firm to assign the responsibilities which they have identified themselves, which aren't included in the list provided by the central bank, and the firm must assign those also to one individual, one PCF within the firm.
Okay, thank you. And in terms of the responsibility maps and statements, what will these look like in practice?
Well, the responsibility statements, we know what they look like. Thankfully, there's a template provided in the draft regulations. Very straightforward. Drop down menus, select the inherent responsibility applicable to the PCF, select the prescribed responsibility. There is a free text box to deal with any other responsibilities or to deal with any clarifications. But the central bank have made it very clear they don't expect there to be lengthy essays included there. In fact, they refer to 100 to 200 words as adequate to cover any additional or other responsibilities. The statement needs to be signed by the PCF themselves and version controlled, so that as responsibilities evolve over time, and that there's a track of the versions. The responsibility management responsibility map is a little bit more complex. Well, depending on the scale and complexity of the firm, there isn't a one-size-fits-all template. The central bank have provided some guidance. It should contain org charts for the firm. It should contain details of the committees, the governance structures of the firm. It also needs to contain a summary of the management responsibilities, so in effect a summary of the responsibility statements themselves. And it's likely to be a combination of graphics and text and charts. And like I say, depending on the scale and complexity of the firm, it will vary. It does need to also include any group relationships or the input of any group committees and any outsourcing arrangements that the firm might have.
Thanks, Keith. And Colman, if we could just go back to you then, how will firms and individuals, I suppose, ensure compliance with the framework, and who within the firms will be responsible for this compliance?
Yeah, so the guidance makes clear that the regulator's approach to the IAF is one of proportionality, predictability, and reasonable expectations, and that a key concept of the legislation is the taking of reasonable steps by individuals to discharge their responsibilities and roles. If it stopped there, I think that would be quite difficult for people maybe to get their heads around, and it's obviously all quite high level. So what the central bank has done through their guidance in chapter 3 is they have a reasonable expectations or steps, and this basically assesses various kind of steps that firms can take in order to seek to comply with the various requirements under the legislation, so both under SEER and under the conduct rules. So when assessing these, I always kind of look at the example, and Keith already kind of touched on it already. If you have a youth management company with 10 employees, even if they're all CFs and PCFs, that's a very different kind of look for compliance than a big bank or a big insurance company. So equally on the conduct side, where responsibility maps will be very different and very particular to an organisation, it will be the same approach of proportionality on the conduct side. So the reasonable steps include the nature, scale and complexity of the firm, and then it looks at kind of the individual, so the functions of the person and the level of knowledge or experience that that person would reasonably expect to have, how long that individual has been in the role, the awareness of regulatory requirements to that specific role, ongoing professional development, including the training that's made available by the firm, and then at a more kind of general level, are there appropriate and effective procedures in place at a firm level? On your second question, in terms of who's responsible for this, so you don't have the same allocations on the conduct side in terms of those responsibilities, whether they're inherent or prescribed. So what the guidance makes clear is for firms falling outside the scope of SEER, which obviously will be a lot of firms that we deal with initially, it would be someone like the Chief Executive Officer. And where there is no CEO, it would be someone of equivalent seniority. And their role would be overseeing that the conduct rules are met at both a firm level but also at an individual level. So where training programs need to be put in place, it will be the responsibility of that CEO or equivalent person to make sure that that was happening. Obviously the conduct rules take into account that roles can be delegated to appropriate people with effective oversight.
Thanks. And Keith, then I suppose what practical actions will in-scope firms and individuals need to take to comply with SEER?
Sure. Well, I suppose from the firm's perspective, I think it starts with an exercise to identify the activities carried out constituting the business of the firm and the responsibilities attaching to those activities. I suppose then it's a question of trying to assign those responsibilities to PCFs within the firm, being cognizant of the inherent responsibilities and prescribed responsibilities as set out by the central bank. So a bit of a matching exercise there. The central bank has also said that they expect the responsibility map to contain a confirmation that there are no gaps, and that it is in effect a sum of the responsibility statements. So again, I guess there's a validation exercise that will need to be carried out there in matching the responsibility maps to the responsibility statements rather to the map itself. On the individual side, then I think Colman's touched it on already. There's an emphasis on understanding your role within the organisation and the impact that your role has not only on the firm but on the customers of the firm. And the central bank has stated that it expects or it will assess reasonable steps taken by an individual in the context of whether or not they had the interests of the customer in mind when carrying out those steps. So that might be a slight mentality change, particularly for those PCFs in more business-facing roles. So understanding the role, assessing the information available to you, and is it adequate in order for you to be able to carry out your role properly. There's an expectation that you will challenge where that information isn't of the required standard. And delegation. The central bank on numerous occasions have talked about the adequacy of delegation. So has proper due diligence been done prior to the delegation? Is the delegate sufficiently supervised? Is there proper reporting, etc.?
Okay, thanks. And Colman, training seems to be a very important part of the process to demonstrating the taking of reasonable steps. So what has the central bank said in this regard?
Yeah, so the central bank has made clear that the obligation is on the firm to provide training to its staff that come within scope of the conduct rules, and that's both initially and on an ongoing basis. Training has kind of been referred to throughout the development of the framework. So in those speeches I referenced earlier, training has been mentioned. It's in the legislation, in the Act itself. But now that the consultation is issued, we see it kind of more prominent in the actual draft guidelines where, as you say, it forms kind of a crucial part of the reasonable steps, that training is at the heart really of complying with a lot of the conduct rules. Initially, I think people may not have appreciated the bespoke nature that I think is expected of training modules and programs that are put in place. So it's not necessarily a training at a high level of what the conduct standards are. It's training that is specific to the individual and their role. So again, back to kind of my space and my expertise, when you look at a management company that has certain designated persons responsible for certain functions in reg compliance, risk, distribution, those people are obviously PCFs. So they're going to be under the common and the additional standards, conduct standards, and they would need to be appropriately trained in their areas. So it's not just something that's high level, it will be tailored and suitable to their role as a DP for distribution on the cross-border distribution regulations, etc. The other thing that we've kind of looked at that kind of emphasizes the importance of training is the FCA's review of the equivalent regime in the UK, so the senior managers and certification regime. So looking at the interviews that were conducted by the FCA, going through their report on the review that they conducted, one thing that they kind of came back to a few times when they were looking at the implementation of the conduct rules was that there was a lack of training or a lack of suitable or tailored training. So it's something that we're looking at quite closely for our clients in terms of how they would go about to comply with those requirements, to have those suitable training kind of sessions and modules in place for their staff.
And Keith, could you provide an overview of the changes then to the fitness and probity regime?
Sure. I suppose they're not extensive is the first thing to say. The central bank in the consultation paper talks a lot about the interaction between the individual accountability framework and the fitness and probity framework, and they do see them as separate and distinct, and the fitness and probity framework will continue pretty much as it is. There are some interactions. For example, any new PCF approvals will now require the submission of a responsibility statement as part of that approval process. But the fitness and probity is very much about the individual being suitable to be appointed to the role, whereas the framework deals with when the individual is going to be in the role and the conduct and the standards of behaviour as they perform the role itself. In terms of changes, there are a few. The holding companies will be included within the scope of the fitness and probity regime for the first time. Perhaps most significantly, firms will be required to certify the compliance of all control functions within the firm with the fitness and probity requirements. So there will be a little bit more paperwork and documentation around that. The central bank have indicated that their expectations in terms of the due diligence required to certify compliance of a CF with the fitness and probity requirements have been raised slightly. Those really are the key changes.
Thanks, Keith.
Yeah.
I suppose just before I ask you both for your key takeaways for today, Keith, how long before we can expect the scope of SEER to be extended to other firms?
That's a good question, and one I can't answer. The central bank have been quite clear that they do intend to roll it out to other firms. They've also said that they intend to take on the lessons learned from the initial rollout before doing that. Elsewhere in the consultation paper, they have mentioned that they will review the regime 3 years after its operation. So given it comes into effect in July next year, 2024, that review should be completed in or around summer 2027. So reading between the lines, it seems that might be the most suitable time for them to extend the framework to other firms, but we just don't know for certain.
Okay, thank you. So then just for your key takeaways for our listeners today.
Yeah, I suppose I got mine in early, so apologies for repeating myself. Firstly, for the conduct rules, it's all firms, so no carve-outs. Implementation date 31st of December this year, and similar to SEER, there's individual accountability. So breaches or prescribed conventions are directly enforceable against the individual by the central bank under the ASP. And just to kind of put a little bit extra on that, just because I'm obviously just repeating myself there, a lot of the feedback we would get, and especially in the areas that we work in, is that there's nothing really to see here for us. This is aimed at other entities, not us. And if it ever is aimed at us, it's down the road. It's potentially 2027. We're focusing on what's this week, this month, and maybe in the next 6 months. But the conduct rules will apply across the board to all the entities that I've mentioned throughout. The consultation, as you mentioned at the start, closes midsummer. By the time the regulations or even the guidance is finalised, that only leaves you a few months before the 31st of December, which is a busy period for everyone running up to then. So there's quite a bit involved in the conduct rules, and that's really my key takeaway, is that it does need to be looked at, and probably sooner rather than later.
Thanks, Colman. And Keith?
I suppose as much as we might like to scare people into coming running to us for advice, I think it's probably worth noting that the central bank views this as very much about improving governance standards rather than holding individuals to account per se or pursuing actions against individuals. Important, I suppose, to note also that the burden of proof remains on the central bank if there was any enforcement proceedings, and that's a substantial burden. In other words, they need to establish that the individual hasn't taken reasonable steps to prevent the breach, which will be not straightforward by any means. And certainly the experience in the UK is that there haven't been a tsunami of actions against individuals, far from it. I think it's a handful to date. Other than that, the CBI have talked a lot about this being the basis for a new supervisory framework, allowing them to focus more on the performance of firms and outcomes rather than particular rules-based compliance that they may have had in the past. So we'll wait to see how that might look in the future.
Thanks, Keith, and thanks both. Thank you for all of you who attended our webinar today. And if you have any queries, please feel free to reach out to any of our members on the IAF team or your usual contact in Dillon Eustace. Thank you.